West Bengal, and she is interested in promoting students, internships and others, and she is a regular visitor of IIT Kharagpur and National University, Calcutta. So I welcome Madam to our Damodaran Sanjivaya National University. So I welcome Madam. Thank you very much.
Masters at Calcutta University. She then practiced and competed in the higher judicial services. She was posted as additional district and sessions judge through direct recruitment. She worked as a district judge at Uttar Dinajpur district. She then worked as the director of the West Bengal Judicial Academy. She was then posted as the district judge of Paschim Midnapur district. She then again discharged her services as the director of the West Bengal Judicial Academy. She then held the post of the Registrar General of the Calcutta High Court and the director of the West Bengal Judicial Academy. She was then elevated to the High Court of Calcutta as an additional judge on 18 May 2022. She was appointed as permanent judge on 6 February 2024. Some of her famous decisions include her decision in a single judge bench that removing the undergarments and forcing a girl to lie down without doubt would only be with the intention of ravishing the minor girl, not pampering her, and would amount to rape, among many others.
Irrespective of the post that we hold, because we are in a constant process of learning, either through the statutes or through experiences. Now, Sir has asked me to address all of you on the changes in the criminal laws. As all of you know that the IPC, the Evidence Act and the CRPC, I would rather call them to be the tripod of criminal justice system. They are the triumvirate on which our criminal jurisprudence rests. Now, from 1st of July 2024, we have BNS, that is Bharatiya Nyaya Samhita, in place of Indian Penal Code, Bharatiya Shakshya Adhinayam, in place of the Indian Evidence Act, and Bharatiya Nagarik Suraksha Samhita in place of CRPC. So all of you must be having a brief idea about what IPC, the Indian Evidence Act, as well as CRPC puts forth. All of you must be having that idea, yes or no? So at the first instance, I would be dealing with the changes that have been brought in the BNS, that is Bharatiya Nyaya Samhita. Now, at the first instance, it might arise in your minds as to what necessitated the changes. We were functioning prior to 1st of July 2024 with the IPC. So what was so impelling that the IPC had to be modified? The main highlights of the objectives is, or rather are, the simplification of the legal complexities by streamlining the provisions relating to the offences and the penalties. There had been an introduction of community services for petty offences. Community services for petty offences had been introduced. The fines and punishments for various offences had also been suitably enhanced. The offences against women and children had been given chronological precedence. The offences against women and children came before the offences against human body, offences against state, offences relating to army, navy and air force, offences relating to elections, so on and so forth. So in the chronology of offences, the offences against woman and child is mentioned in chapter 5 from section 63 to section 99. There had been certain new offences pertaining to terrorist acts and organized crime which have come up with deterrent punishments. And various offences against the state have also been introduced. The offence of sedition has been deleted. You can take note of section 48 of the BNS. Now what does section 48 say? Section 48 is a new offence which punishes any person, including a foreigner, who while being outside India abets the commission of an offence in India. So earlier the Indian Penal Code was restricted within the jurisdiction of India itself. Now it has been given an all-pervasive jurisdiction. So a person sitting outside India, if abets the commission of any offence, will be punishable under section 48 of the BNS. There has also been a progressive change in section 210 of the BNS, wherein while defining the term gender, the pronoun he has been used, which is applicable to a male, female as well as a transgender. The word child has been defined under section 2.3, section 2 subsection 3 of the BNS. There have been certain archaic words which post-independence have become redundant. They are no longer significant. Such words are Queen, British India, Servant of Government, India, Government of India. So these words which have lost its relevance post-independence have been deleted from all the provisions which had earlier enumerated them in the Indian Penal Code. Now, as we come to the offences against woman and child, the definition of rape under section 375 IPC is more or less replicated in section 63 of the BNS. What does it say? Save and except the modification in exception 2, whereby the exception is made applicable to sexual relationship or acts between a man with his wife, provided she is 18 years or and above. You can also write down a decision of the Supreme Court and can go through it later on. That is Independent Thought versus Union of India. The citation is 2017 10 SCC 800. Now Supreme Court here has mentioned that an act will not fall within the definition, that's an exception, of rape under the situations that has been mentioned in the citation that I have provided. It has got its sink in the definition to the exception 2 of rape. There has been a separate offence under section 69 of the BNS which penalized, this is a new section, which penalizes sexual relationship or acts by employing deceitful means, on the ground of false promise of employment or promotion, inducement or marrying after suppressing identity, or by making promise to marry without intention of fulfilling the same. This was not there in the earlier act. This offence overlapped with the offence of rape, and now it has found its way in section 69 of the BNS. Now, in certain offences, the gender of the offender is no longer relevant. Section 76 of the BNS, this also you can write, that is assault or criminal force to woman with intent to disrobe. This was earlier a part of section 354 of the IPC. Now it has been categorically mentioned in section 76 of the BNS. Here, and also section 77 of the BNS with regard to voyeurism. It mentions any man, as was used under the section 354B and 354C of the Indian Penal Code, has been replaced with whosoever. Thereby, it has created the liability upon a person irrespective of the gender. Section 96 of the BNS and section 141 of the BNS mentions procuration of child and importation of girl or boy from foreign country. This was earlier dealt under section 366A and 366B of the Indian Penal Code. So now it has been bifurcated under section 96 of the BNS and section 141 of the BNS with certain specification. Now the word minor in the new BNS has been changed with the word child. Minor is no longer used, but it is used as a word child. Now earlier, section 366A and 366B penalized procuration of minor girl and importation of girl from foreign country respectively. Now the section 96 of BNS and section 141 of BNS have made it gender neutral. So the victim can be a male child, the victim can also be a female child. So it has made the entire process with regard to the victim to be gender neutral. Now section 95 of the BNS, it creates a new offence which penalized hiring, employing or engaging a child to commit an offence. Now the unnatural offences which was enumerated in section 376 of the IPC have been deleted. So under BNS there is no offence stipulated as the unnatural offences which was earlier there in the IPC as section 377. Now, why was this done? This deletion not only decriminalizes consensual sexual intercourse or acts, as it was declared unconstitutional in Navtej Singh Johar and others versus Union of India. This also you can write down. Navtej Singh Johar and others versus Union of India. The citation is 2018 10 SCC 1. So from there you can understand as to why the unnatural offences have been deleted from BNS. So following the observation of the Supreme Court, a statutory recognition has been given pursuant to the observation in Navtej Singh Johar and others versus Union of India. Now, certain aspects have been introduced in the offences against human body. Sorry? Navtej Singh Johar and others versus Union of India. Have you got it? So now, offences against human body, there are certain new offences added. One of them being mob lynching. This mob lynching was not there earlier. In the offence of murder, a subcategory called mob lynching has been introduced. Mob lynching occurs when a group of 5 or more persons act in concert to commit murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground. Punishment for each member of such group is equivalent to murder under section 103 of BNS. This introduction is in response to directions given by the Supreme Court to combat mob lynching in Tehseen S. Poonawalla versus Union of India. This also you can write down. Tehseen, Tehseen, Tehseen S. Poonawalla versus Union of India. The citation is 2018 9 SCC 501. Now let's see what Supreme Court in this particular decision has pronounced. The Supreme Court has denounced the occurrences of lynching and mob violence against Dalits and individuals belonging to minority communities as deplorable acts of mobocracy. The court has urged the Parliament to enact legislation recognizing lynching as a distinct criminal offence with commensurate penalties. The proposed legislation should be robust enough to instill a sense of apprehension in potential perpetrators. You must have come across in the newspapers, in villages, a lady is identified as a witch and then the mob lynching happens. Somebody had stolen maybe a very trivial material from a house. So the mob acts immediately to punish. Instead of, apprehending or calling the police, they immediately come into action. So there are myriad examples to such. Court has comprehensively opined as to how the legislature should consider mob lynching to be an offence, and in view of the decision in this Tehseen Poonawalla versus Union of India, the offence of mob lynching has been subcategorized in the definition of murder under section 103 of the BNS. Supreme Court had further observed, it is also the obligation of the centre and the states to ensure that nobody takes the law into his or her hands nor becomes law into himself. Apart from the directions we have given herein before and what we have expressed, we think it appropriate to recommend to the legislature, that is the parliament, to create a separate offence for lynching and provide adequate punishment for the same. We have said so as a special law in this field would instill a sense of fear for law amongst the people who involve themselves in such kinds of activities. There can be no trace of doubt that fear of law and veneration for the command of law constitute the foundation of a civilized society. Thereafter, another provision, that is causing death by negligence, has been introduced, where there have been separate sets of punishment for different categories of negligence which had been curated. Number one, causing death by negligence by any person other than a registered medical practitioner under section 106(1) of the BNS. And here the imprisonment is of either a description which might extend till 5 years and also with fine. So medical negligence forms a part of a different act, and here any negligence which would result in the death of a person apart from a registered medical practitioner falls within the parameters of causing death by negligence. Then comes causing death by negligence by a registered medical practitioner under section 106(1) BNS, imprisonment of either description which may extend to 2 years and 5. Causing death by rash and negligent driving and escaping without reporting it to a police officer or a magistrate soon after the incident, that is hit and run cases. It is comprised in section 106(2) of the BNS, and the imprisonment would be either for 10 years, which may extend till 10 years, or with fine. Now this portion has not yet been notified. The punishment to extend till 10 years and fine has not yet been notified. But the offence of causing death by rash and negligent driving and escaping without reporting it falls within the definition of section 106(2) of the BNS. Another important instance is the offence to attempt to commit suicide. This has been deleted. Attempt to commit suicide under section 309 of the IPC has been deleted, again following the decision of Supreme Court in Aruna Ramachandra Shanbog versus Union of India, and section 115 of the Mental Healthcare Act 2017. You can write down the decision of Aruna Ramachandra Shanbag versus Union of India. It is cited in 2011 4 SCC 454. However, a new offence has been added under section 226 of the BNS, which penalizes attempt to commit suicide to compel or restrain official duty. So it has been restricted in its scope, not universally applicable to any attempt to commit suicide, but only in cases to compel or restrain one person in it discharging his or her official duty. A new offence has been introduced that is called organized crime, involving continuing criminal activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons, or illicit goods or services by two or more persons is made punishable under section 111 of the BNS. So earlier, these kinds of offences were dealt as a cognate offence of other sections. But now, in the BNS, it has found its definition under section 111 of the same. Apart from organized crime, in section 112 of the BNS, you find the definition of petty offences. So 111 gives you the definition of organized crime, and section 112 gives you the definition of petty organized crime. Now, what are petty organized crime? It involves continuing criminal activity including theft. Now, organized crime, betting or gambling, selling of public examination question papers, etc., by two or more persons have been made punishable. In addition to this, under the special laws like the Unlawful Activities Prevention Act 1967, Terrorist Act through section 15 of Unlawful Activities Prevention Act 1967 and the Terrorist Act, similar to these two special laws, certain acts have been made punishable under section 113 of the BNS. Explanation to the provisions clarifies that the officer not below the rank of superintendent of police will decide whether to register the case under this section or under unlawful areas, which will determine with regard to the nature of the offence committed as to whether it will fall under BNS or under the UAPA or the Terrorist Act. Now, apart from the grievous hurt as defined in section 326 of the IPC, there has been the introduction of a new section, that is 117(3) as well as 117 subsection 4 for grievous hurt resulting in persistent vegetative state or permanent disability in cases of mob lynching. Vegetative state, what would you generally mean by a vegetative state? That a person cannot respond, that a person cannot move. It's kind of a state where one undergoes coma. We generally say the person is in the state of coma. So it is akin to that particular stage where we call, or where it is seen to be in a vegetative state or permanent disability, that is, a person is unable to perform any kind of work. That too through the offence of mob lynching. And beggary has been introduced as a form of exploitation for trafficking under section 143 BNS. So earlier, beggary was not there in the definition of trafficking. So, girl child or a boy child can be trafficked and they are compelled to act as beggars on the street. You can find in the traffic or else on the pavements. They are made to get involved in the profession of beggary. So earlier this part was not there. Now they have included beggary also to be one of the modes whereby a girl child or a boy child is trafficked. It comes under section 143 of the BNS. Now we have the changes with regard to offences against state. Sedition under section 124A of IPC has been deleted. Now what we have? We have section 152 of BNS, which has added a new offence which punishes secession and separatist activities, armed rebellion, subversive activities, or any act which endangers the sovereignty or unity and integrity of India. So here what is meant by secession and separatist activities, where certain acts of a particular group of people threatens the unity of the country, the sovereignty of the countries. They want to separate out. They want to create disharmony, discord, terrorism, hatred. So these kinds of activities are now dealt with under section 152 of BNS. Next one is under section 197 subsection 1 clause D of the BNS, which makes the act of making or publishing false or misleading information which has tendency to jeopardize the sovereignty, unity, integrity or security of India as a new offense. So all of you are on social media. Most of your time is consumed by Facebook, Instagram, TikTok, YouTube, right? Since you are still young, you have no idea as to what cyber crime and cyber offenses are. Knowingly, unknowingly, you can fall a prey to certain kind of offense. So I would take this opportunity to ask all of you to refrain from commenting on social posts which can be detrimental in future for each one of you. You might feel yourself to be very proactive, you are very concerned, and you make such comments without even knowing that the trail mail will include your name, which can have intense ramification. Therefore, you should deliberately preclude to make comments and discern for yourself whether you should do it or not, whether it will affect the community at large. It can also be a case of defamation against you, because you never know what is the original fact is. Let me give you an example. Though it's an ongoing case in my court, but I will not reveal the subject matter. Somebody comes and seeks for personal safety, stating that I have fought for a particular social cause and I am being threatened. So I need safety, I need security, so the court should provide me CISF protection. So do you know who is a CISF and who are the people who are entitled to CISF protection? The court can't grant CISF protection. Only the Ministry of Home Affairs can, and also not to everybody. Now this particular petitioner comes for quashing of a complaint against the petitioner. There has been a complaint against the petitioner. So the petitioner has come to the court for quashing that complaint. complaint. And now do you know what is quashing a complaint is? That there is no material in the complaint which should entail a trial against the person concerned, so the complaint should be quashed. So this has been the prayer of the petitioner. Now who is the petitioner here? The petitioner here is an accused. The accused comes to court with a plea which is separate from the complaint that has been instituted against the petitioner and seeks CISF protection. The court says, it's not possible, we can't give you this. So what the petitioner does? Clips, now you can find YouTube live sessions of court proceedings. The petitioner creates a new video, just clipping certain instances. And then it gets it posted on the YouTube. People see it without knowing an iota of the subject matter. One can see a petitioner pleading before the court for mercy that my life, my property they are endangered, I am being threatened day in and day out. The court has to see whether the claim of the petitioner is at all justified. It can be considered. No, the court says you behave yourself. Why are you shouting? Why are you not maintaining the decorum of the court? Then what happens? Volley of comments that the judge is inconsiderate, the court is not functioning well, a person is there before the court pleading for safety, the court is not granting safety. Now it might so happen that any person can file a defamation. You never know the actual facts. Nobody knows the actual facts. But they go on commenting because they find 20 others have already commented. So blindfoldedly you also type out something. Suppose a complaint is lodged and the entire circumstances are found to be false. There can be an institution of defamatory suit, or under the criminal law also defamation against you. So be careful, because in the era of cyber crime, anything and everything can happen or is possible under the sky. So one has to be extremely alert and caution, or rather alarm yourself not to fall prey or get into the trap. So this would again fall under section 197 1D of BNS, of the act of making or publishing false or misleading information. Now what are the changes that have been made with regard to offences against property? One is snatching, which is very common. I mean, you can find numerous newspaper reports that in the morning somebody is walking on the pavement for morning walk, somebody comes and snatches the necklace or whatever, the handbag or stuff like that. So snatching has been made an offence under section 304 of the BNS, which has been a part of theft, or rather a new form of theft, where the property is quickly or forcibly seized or grabbed. This offence may be attracted in cases where theft is accompanied by use of criminal force but does not transcend to robbery. So anybody can come, snatch your mobile, snatch your purse, snatch your necklace, rings or whatever, or one of your belongings through application of force, and leave. But this will not amount to robbery. Now, earlier under section 444 of the IPC, lurking of house trespass by night was an offence which has now been deleted, and housebreaking by night, which was there under section 446 of the IPC, have also been deleted. Now let me tell you some of the major changes in the punishment of certain offences. Now, abetting commission of offence by public or more than 10% of. Now, this has found its place in section 57 of the BNS. Now, section 57 of the BNS, it stipulates abetting commission of offence by public of or more than 10 persons. Earlier under IPC, the punishment was of 3 years. So now it has become a punishment of 7 years with fine. The punishment for rape is now defined under section 64(1) of the BNS. The punishment was minimum for 7 years under IPC. Now it has become a minimum of 10 years under BNS. Buying of child for purposes of prostitution is now defined under section 99 of the BNS. Earlier it was, the punishment was to extend up to 10 years and fine, and now it has been extended from 7 years to 14 years. That means it cannot be below 7 years, but it can extend till 14 years. Earlier it was only till 10 years. What's the difference? Extend till 10 years means it can be 3 year, 4 year, 5 year. But now it should be within 7 to 14 years. That means it can never be below 7 years. Punishment for culpable homicide not amounting to murder is defined under section 105 of the BNS. Earlier under the IPC, the punishment was life imprisonment or may extend up to 10 years and fine. If the act was done with intention of causing death or of causing such bodily injury as is likely to cause death. But now it has been changed under the BNS as life imprisonment or 5 to 10 years. Again, if it is mentioned as 5 to 10 years means it can never be below 5 years. 5 to 10 years and fine. And if the act was earlier done with knowledge that it is likely to cause death but without any intention to cause death or to cause such bodily injury as is likely to cause death, there is a difference of knowledge that an act might cause death and an intention to commit the offense knowing fully well that I have premeditated the act with its extreme plausible reason to cause only death of the person. Secondly, you did not have the intention to cause death, but instantly, under provocation or any kind of instigation, you do certain act which you might have the knowledge that the intensity of the act might result in death of a person. So in this case, earlier the punishment extended to 10 years or fine or both. Now, under the BNS, it will extend to 10 years with fine. Earlier it was extending till 10 years or fine or both. Now or fine portion has been deleted. It will be extending till 10 years and with fine. Causing death by negligence, as I have already told you. Earlier it would extend till 2 years or fine or both. Now it will extend to 5 years and fine. Voluntary causing hurt. Earlier it would be extended till 3 years. Now under section 121 subsection 1 of BNS, it will extend to 5 years or fine or both. Voluntary causing hurt or grievous hurt on provocation falls under section 122(2) of BNS. Earlier the punishment was till 4 years or fine. Now it will be 5 years or fine. Wrongful confinement for 3 days or more subjected a person to a punishment to 2 years or fine or both. Now it will be 3 years or fine. Maximum fine would be 10,000 rupees. Exploitation of a trafficked person. Earlier it was 5 to 7 years. Now 5 to 10 years and 5. So earlier also the fine was mandatory. Under BNS also fine is mandatory, but it was for 5 to 7 years, and under BNS it is for 5 to 10 years. Rioting was earlier punishable for 3 years, now it has been made punishable for 5 years, or fine or both. Adulteration of drugs, earlier it was for 6 months punishment and rupees 1,000. Now it is 1 year of punishment with a fine of rupees 5,000. Criminal breach of trust under section 316 of subsection 2 of BNS provides punishment for 5 years, which was earlier for 3 years. Cheating under section 318(2) of BNS, it makes the punishment for 3 years or fine or both. Earlier it was for 1 year or fine or both. Cheating with the knowledge to cause wrongful loss, it was earlier 5 years or fine or both. Now it's 3 year or earlier it was 3 years for or fine or both. Now it has been made 5 years or fine or both. Dishonest or fraudulent removal or consignment of property. Earlier it was 2 years, now it has been made 3 years of punishment. Mischief, earlier it was 3 months, now it has been made 6 months. So these are the changes in the punishments. There are also certain offences where minimum punishment has been prescribed. That is under section 95, hiring, employing or engaging a child to commit an offence. Section 99, buying child or for purposes of prostitution, as I have said. Section 5, punishment for culpable homicide not amounting to murder. Section 111, subsection 2, subclause B, that is organized crime, abetting, attempting, etc. of an organized crime, being a member of the organized crime, harboring a member of organized crime, possessing property derived from organized crime, possession of property on behalf of a member of organized crime. So under section 111, which defined organized crime, the subsections and the subclause have defined the cognate crimes. Similarly, under the section 112(2), where the definition of petty organized crime is given, punishments have been stipulated. Then again, kidnapping or maiming a child for purposes of begging. personating a public servant, theft, dacoity, etc., etc. Earlier, it would come under either section 511 or the principal section. But now, against each and every offense, a punishment has been prescribed. Now, I would like all of you to take down one decision and then go through it. That is State of Sanjeev Nanda. 2012, 8 SCC 450. From here, the concept of community service has been mentioned by the Hon'ble Supreme Court, which has now been incorporated in the statute of BNS. Now, what does it say? In the hit and run case, the Supreme Court observed that the intention was inferable and the incident occurred in an unexpected situation, mark the words, leading to the adoption of community service as the punishment. Given the loss of 6 lives, the court deemed this method more beneficial for society than further incarceration. Additionally, fines would help compensate the victims of such accidents. The court perceived that convicts in various countries now voluntarily serve the community, particularly for motor vehicle related crimes. The graver the crime, the greater the sentence. However, serving society allows convicts to repay their debt in a meaningful way. This is the observation, this is the objective, that once you have committed an act which is grossly wrongful, without intention, but you should realize, if or at all there was certain intention, you should realize that you have committed a wrong, a misdeed, and you need to rectify yourself or realize the consequences that the victim has suffered yourself too. This conduct is appreciated by the community and provides solace, especially when human lives have been lost due to one's actions or inactions. Convicts in various countries now voluntarily come forward to serve the community, especially in crimes relating to motor vehicles. Graver the crime, greater the sentence. But serving the society actually is not a punishment in the real sense, where the convicts pay back to the community which he owes. Conduct of the convicts will not only be appreciated by the community, it will also give a lot of solace to him, especially in a case where due to his own action and inaction, human lives have been lost. The accused would do community service for 2 years, which will be arranged by the Ministry of Social Justice, and empowerment within 2 months. On default, he will have to undergo simple imprisonment for 2 years. So this has been observed by Honorable Supreme Court in this particular case. There is another case which is called Gudikanti Narasimhalu and others versus Public Prosecutor, High Court of Andhra Pradesh, that is 1978, 1 SCC 240. In this case, the Supreme Court of India emphasized the need for bail to balance social defense and individual rehabilitation. It stressed minimizing punitive measures while prohibiting behavior that undermines public trust. like tampering with evidence or intimidating witnesses while on bail. The decision supported restorative measures such as community service and educational programs for rehabilitation. In the words of the Supreme Court, a few other weighty factors deserve reference. All deprivation of liberty is validated by social defense and individual correction along an anti-criminal direction. Public justice is central to the whole scheme of bail law. Fleeting justice must be forbidden, but punitive harshness should be minimized. Restorative devices to redeem the man, even through community service, meditative drill, study classes, or other resources, should be innovated. And playing foul with public peace by tampering with evidence, intimidating witnesses, or committing offense while on judicially sanctioned free enterprise should be provided against. No seeker of justice shall play confidence tricks on the court or community. Thus, conditions may be hung around bail orders not to cripple but to protect. Such is the holistic jurisdiction and humanistic orientation invoked by the judicial discretion correlated to the values of our Constitution. So based on these observations, community service has also been prescribed as a punishment. But again, it is not defined as to what exactly would be the community service. That is upon the court from time to time, cite examples, give situations, and also through judicial pronouncements, a list perhaps will be created with regard to the types of community services that the court can avail of. So this, in a nutshell, had been the changes in the IPC that has been brought in the BNS. Thank you so much.